Take that long that lead us piece. Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Wednesday, March 12th, 2025 at looks like 10:28 in the morning. So now we're back to continue our discussions with the Secretary of State's office on H-243, which is a regulation of business organizations. David, thanks for coming back in this morning. We'll actually finish up kind of a high level walkthrough of the bill, and hopefully you're coming on later. Yeah, okay, so we'll walk through with Rick and
Okay, well, good morning. For your record, David Hall, Director of Business Services Division from the Office of the State. Can I share my screen? You guys good with that?
Yeah.
Sounds like you've been having a busy day already. Good for you. I'll try to make it more painful.
Your dedication.
That's not what you mean. Okay, so I'm going to go back to the overview document that we are working from, that's color coded, that talks in conceptual strokes, the framework of the changes, and then we can look at the language in the table for you to see how the words manifest. We talked about already the agent for service of process. We've talked about harmonizing initial filings and AR information. We talked about harmonizing name provisions. Yesterday, we did the assumed name, reserved name, registered name. I think we can. Yeah, we've got four components left. One is the fees. One is service of process provisions. One is administrative procedure and authority. And the last one is the study provision. So do you want to quickly talk fees, or do you want to skip that? How do you want to tackle that?
I think you already touched on fees high level, that you're just trying to make it more equitable for everyone. I don't want to get deep in the weeds on fees because that's not our jurisdiction.
Sure.
And once we pass this out, it's going upstairs.
Yeah.
So I think we should save that fund for ways and means.
Okay. So what I'll say about that, and then we'll move on, again, because, it is part of the proposal. It is something that this committee will have to vote on. And I understand that the thing that I'll offer is that we're just trying to standardize here and be policy and revenue neutral. As I talked, and you can look on the testimony that I submitted with a fee comparison table. And then there's also the entirety of the chart I built that shows every document's fee for every filing. And you'll just see it's just all over the map and for no good reason. I can't tell you why it should be $20 to file the exact same document for a corporation as it's $35 for an LLC. It makes zero sense. It's inequitable between the entities. So, the net result, some things would go up, some things would go down, but on balance, I'd like it to be revenue and policy neutral, just sort of fair and makes sense. So when somebody asks, what's the fee for that? Most of the time, the answer is going to be $35. But we can move along. So service of process provisions, this, what's going on here is a lot like what we talked about with the reservation of name provisions yesterday. I talked to you through how they're mostly the same, but then each entity has its own nuance, its own unique flavor, whether, for instance, you're allowed to renew the reserved name, or you can hold it for a certain time period, or you can, when you actually apply to get the renewal of a reservation, and there's 0 sense for it to be slightly different for every different entity. So we decided, let's pick one path for that and have it apply across the board. It's the same with service of process provision. So we already talked about the agent for service of process. And you may remember on the tail end of that discussion, we talked about what happens if you don't successfully designate an agent, right? So your job, one of the things that you absolutely need to do with us is maintain a resident or an authorized business with a Vermont address to whom somebody in the world can deliver a service of process if it comes through. Some legal notice, demand, they're suing you. We need to be able to find you in this state, exert personal jurisdiction over you, and allow that proceeding to occur. The mechanisms for that process are all sort of laid out in law, but there's a disconnect that might occur when you failed to name an agent, or your agent resigned, or you gave us the wrong information, or after reasonable diligence were unable to find your agent. In that case, the Secretary of State is by law the default agent for service of process, right? So that says basically all of the different statutes say in one manifestation or another that you will actually come to 128 State Street and you will give us the process, the lawsuit, the whatever. We'll take a couple of copies of that. We'll forward that to the last known address as reflected in our records, or what we know about the business that's being served. And we become that process situs and agent, right? As with all these other issues, there are slight differences in the steps necessary to come and serve us as the agent. And so what we've done here in the gray changes that are in your table is to say we're going to pick one, and we're just going to have that govern. The one that we picked is the most recent, basically, pronouncement by this body in 2015 when you guys adopted Title 11C, governing mutual benefit enterprises, that had its own version of the service of process framework. And because that was the most recent one adopted in law, I thought that makes the most sense from a policy perspective to be the one to use. Substantively, procedurally, probably nobody in the universe is going to notice any difference, but we would just like to have the language be the same, so that when our person, Kim, manages a service from the sheriff, she knows exactly where to look. She knows that it doesn't matter what kind of entity it is, it's going to be the same steps. So I'll pull that up on the table and see if I can find a gray highlight so we can read through together what the steps actually look like in law. So you'll see, I mean, this is the first example. It's in 11 BSA 1627. So this is in chapter 15. This is the chapter that governs the assumed name, the partnership, and the UNA. It's got its own, governing those types. We're going to just, in all these instances, we're either going to just strike this out, or we're going to, because it appears in the same chapter, it's going to be a new section. But in other places, for instance, in the LLC Act, we will refer back to that common section and say, service of process for an LLC is governed by or is subject to the provisions of, and that, scrolling. Sorry, don't watch if you are going to get a headache. 1656 will be the section that rules them all. And again, the way this is built in the bill, it's all underlined because technically it's a new section of law in 1656, but the words are already existent in Title 11C. So you'll see Secretary of State as agent for service of process. So an agent appointed by a person registered with the secretary is an agent for service of process for any process, notice, or demand required or permitted by law to be served upon the person. So that's subsection A, blanket statement. If you need to serve somebody something, this counts, this applies, whether it's an actual lawsuit or it's a demand letter or anything else, it can go through this process. So under B, the secretary is an agent for service of any process, notice, or demand for a person conducting business in the state without registering. Okay, so you're doing business here. You're supposed to be registered. You're not, which means you haven't designated an agent. Okay, fine. That means Secretary of State by statute is your agent. Under 2, it's a person registered who fails to appoint or maintain an agent in the state as required by law. Okay, so you are registered, but you don't have a valid agent for some reason. Or 3, a person who's appointed agent for service of process cannot with reasonable diligence be found at the agent's address. So that piece, B3, is from, like I said, 11C. That piece, the reasonable diligence piece, is not in some of the other underlying service of process provisions. So this will make sure that no matter what kind of entity you are, the reasonable diligence component is applicable to you. Under C, service of any process, notice, or demand on the secretary may be made by delivering to and leaving duplicate copies of the process, notice, or demand. If it is served on the secretary under 2, secretary shall forward one of the copies by registered or certified mail, return receipt requested to the person at its principal office or last known address as reflected in the records of the secretary. So again, that's one of the steps that we want to be the same across the board. Duplicate copies and duty to forward at the last known as reflected in the records. D is also taken from 11C. It is another element that's not necessarily present in all the various service of process sections currently in law, so this would make them applicable. And this just talks about when that service is actually effective. It's the earliest of the date you receive it, the date shown on the return receipt if signed on behalf of the person, or 5 days after it's deposited by us in the mail, if prepaid to the address reflected in the records. E is a very common provision. Secretary shall keep a record of all of these processes and record the time of the action taken regarding the service. And F, this shall not affect the right to serve process, notice, or demand upon a person in any manner otherwise provided by law. So there may be nuance in particular proceedings, for instance, for, let's say, captive insurance companies, or, maybe there are specific provisions in the rules of civil procedure about how you need to deliver certain types of process that's governed by court rules, not us. This just says we're not going to change that. We're building a sort of a generic template for how to do this. So again, will anybody notice the difference that we've tweaked these words a little bit? Probably not. Our process is pretty much the same anyway, but we just want the standard language to govern across the board rather than having to deal with the nuance of, 8 slightly different service provisions. Any questions on why this is happening or how?
That's actually exactly what I'd like to know. Mr. Hall, is the thought then that the secretary can continue along a process that would otherwise be frustrated because they are not the agent, that by becoming the agent, this allows for things to move in a more expedient manner because there is one?
Sure. I mean, I'd like to say yes. I'd like to say that, this is a huge improvement, but truthfully, this is not really going to change much.
To just be these consistent.
Yeah.
To our saying.
Yeah.
Okay.
I mean, this already exists across the board, that the Secretary of State becomes the default agent if your agent appointment fails for whatever reason. So no change there.
Yeah, the day-to-day activity in each instance of these 8 different whatever elements leads to this point, but it's wiser to have that point be delineated in this language for all intents and purposes.
I mean, that's the
That's the goal.
conclusion, is it should just be standard across the board. Yeah. Sure. So you'll see here in 11 VSA 4010, you know, uh, most of the same elements. But the way that we would structure, as I said, is that instead of having you know, 9 or whatever different service of process sections, we would just say LLC or foreign LLC, all subject to the same thing.
Okay.
Standardized.
Just pick up data brokers.
I mean, they would be subject across the board to every of each of the same provisions. If they're doing business here, they should be registered with us. If they're registered with us, they should appoint an agent. If they fail to appoint an agent, we're the agent. If service comes to us, we have this process and the duty to forward the service to the data broker or anybody else for that matter.
We'll be chatting about data brokers this afternoon.
That is very exciting. Envy your position. All right. Okay. So I think we can all get excited about this administrative procedure and authority. So I will say, you know, perk your ears up. This is probably the one part of the bill where there is substantively something new. And I think it's important. Not all of the administrative procedure and authority things are new and exciting, but the parts about potential fraud or, mistake or false information and what we can do about it, those are new and I think important. But I would like to look at these, all of you. So sections in yellow reflect additions, amendments to law relating to the Secretary of State's administrative authority. And the way that manifests in the statute is that within 11 VSA chapter 15, you'll see we will break that out into subchapters, and there will be a whole subchapter dedicated to the Secretary of State's administrative authority. That's where most of these things will be grouped together. There's already some provisions that relate to that, and then we'll add a couple more. The first one, though, is not that exciting. Forms, procedures, and rules. You would think that there would be some blanket delegation of authority for the secretary to adopt forms, procedures, and rules across the board, but there's not. It appears in some of the business organization statutes, but not all of them. Some of them say that the secretary has a sufficient authority to implement the provisions of this chapter or this title. Others do not. And so, that leaves us in this funny position where it's like, well, can we really do the rule for this? I mean, we obviously have the authority for UCC rules, but we don't obviously have the authority for other things. And that doesn't make a lot of sense, considering that a lot of what we do is either, build a form, and Neil Rhodes, my colleague, is with me, and this man spends a lot of time building these forms. It is a very difficult and time-consuming process. There are tons of them, but I would like to be on a clear footing and point to a provision of law that says we adopted this form pursuant to X. Same with procedures and rules. I don't know how deep of a dive you guys have done on this. Basically, a practice or procedure is just how an agency does its business in a practical or procedural manner, right? So what are the steps we're going to follow if we, have a complaint about something or we need to fix an error in the database? It's not always written down. It can be, and people can demand that it be, but it's usually just like operational issues. And then rules are governed by law, right? 3 VSA chapter 25, Vermont's Administrative Procedure Act, same at the federal level. That is where the legislature or the executive have delegated by law the ability to adopt rules. And there are two kinds of cases governed under that chapter and that would be applicable to us. One is contested cases, and we'll talk about that later in the context of the fraud. And the other is the rulemaking process. And you're probably at this point at least heard of that, where if an agency wants to adopt rules pursuant to specific authority delegated to it, it writes the rules, it brings it to LCAR, LCAR reviews it. If LCAR approves, they take effect, they have the force and effect of law. They can only be subsequently changed by rules. So that is a much more formal process than a practice or a procedure. So we just here basically are saying, rather than have a mishmash of this authority in this title but not the other, we're saying across the board, the Secretary of State has the authority to adopt forms, procedures, and rules to implement the specific provisions relating to business organizations. And again, if we ever need to go through a rulemaking process, and we will, to update our UCC rules and our name rules, then that will be governed by the Administrative Procedures Act. It will be subject to legislative review, and it will, have the force and effect of law if approved and adopted according to the steps in law. So that's the first piece. And we can look at the actual language, but that's the conceptual framework. The second piece is amendments, closure filings, and agent service of process provisions for assumed business names, partnerships, UNAs. We already talked about this. I now think told you twice. I highlighted it as yellow, but it could be green as well. So this is the stuff we looked at yesterday concerning those three registration types and the harmonization of what you need to include in your initial filing, that you're allowed to file amendments for these types of filings, that you have a closure if you stop doing business, as we talked about. So we actually already covered the second piece, but I wanted you to know why it's included here under the yellow, because it does affect our administrative operation to the extent that it will change what some of the filings are and what they're called for instance, our partnership. It will make life much better for them and for us if we're able to, for instance, authorize an amendment to registration for a partnership or an assuming.
So if I close my corporation, I don't file with you to tell you that I've closed it, what actions can you take against me because I didn't file?
You didn't file a closure filing? I don't think there's really anything that we do. We don't police the termination of businesses.
The consequences, not to the corporation, but consequences in the real world for you not letting the Secretary of State's office know that you've closed.
There can be, as long as you're technically still an entity, there are minimum tax filings every year for different organizations. I think it's, last I checked, it was like $250 for an LLC, for instance. So you're, as long as you still technically exist, you're supposed to be paying the minimum filing.
That's the
Yeah.
kind of catch.
Yeah. The stick.
Yeah. So you're going to continue to pay taxes on that corporation
If you do.
if you don't close it. And and the way to close it, you have to officially file the form, Secretary of State. Okay. Emily?
To follow up on that, if somebody just kind of splits, does not report the closure, stops paying their taxes because they just sort of closed their business in whatever way they thought, do you, and they're racking up that $250, do you have authority to go after them?
That's not us. That would be Department of Taxes.
Okay.
Technically, do they? Yes. Would they? I don't know. Once a business is shut down, it's no longer generating revenue. It's defunct. Blood from a turnip. Blah blah blah. So I don't know. I don't know that they would, but they could theoretically. The other bit is, for closing out financial accounts, for instance, like at your financial institution, like they'll want to see that you have terminated officially and they close your records to make sure that nobody tries to reopen the business or get more credit under that name. That can be an issue. So it's also best for you to file a final closure filing, have the record reflect. I think that's the best way to protect yourself. And if we're talking about carrots and sticks, as long as your business is just sort of hanging out there, it's at least theoretically possible that somebody could reinstate it and then try to use your business credit to restart activity. So it's really the best practice for protecting yourself in the future would be to close the business officially in the records of the Secretary of State. And you're supposed to, so, but. Any other questions on that?
To the next one.
Yeah. So so this is the big one, the authority to reject, amend, or terminate records. And I think I'll read the bullets together with you. So currently, the secretary does not have clear express authority to address cases involving false, fraudulent, or clearly erroneous information. Recent examples include amendments submitted without legal authority, fraudulent use of a valid physical or mailing address, initial filings with erroneous information, for instance, address in a town that does not exist in Vermont. And the proposal here is to add a new section, 1638, which would give administrative authority to the secretary of two varieties. One, to reject a record that contains false, fraudulent, or clearly erroneous information. And two, to amend a record or terminate a registration after notice and opportunity for hearing. That's the contested case provision of the Vermont APA. If a person has submitted false or fraudulent information in a record or submitted a record for filing in bad faith without lawful authority or to commit fraud or cause injury. And then a person aggrieved by a decision would be able, like in 1636, to appeal de novo to the civil division in Washington to Superior Court. So I want to look at the actual language of this with you, but I want to unpack first the concepts underlying this proposal. So when I say that the secretary does not have clear express authority to address cases of false, fraudulent, or erroneous information, that comes down to the fact that our duty under law is ministerial in nature. And I don't know if you've heard that term yet this year, but there's basically two kinds of authority, of practice in executing the laws in an agency. One is ministerial, and that just means if the person checks all the boxes, you take the document and you file it, and you don't have anything else to say really about whether it's true or not, good or bad, etc. And if they've done something wrong, if they've submitted a false document or information in that record, then they've committed perjury, probably. And that brings us back to this issue we were talking about, where now I have to call the police and the AG's office and go to court. And that is an extremely cumbersome process, which in reality just doesn't happen, right? The other type of authority is more like permitting, where the DEC needs to weigh factors and decide whether you've met the criteria for your wastewater and the design, and can they recommend changes or add conditions to it? And if you satisfy the conditions, and there's more subjective authority for them to have a yes or a no or a conditional approval based on such and such. We don't have that latter. We don't do the latter. We don't do the subjective approvals. We don't have the contingent authority. We have the ministerial authority, except in the process that we discussed under 1636 about the contested name. That is the one place where we sort of have some subjective authority, and we have had a handful of those. When that happens, it is a contested case. We give notice to the parties to come to Montpelier or by video to present their case and substantiate whether they are doing business under a name. We take evidence. We give the witnesses a chance to hear from each other or question each other. And when it's over, we issue a finding of fact and conclusion of law and a decision in order pursuant to the APA. So that's a very formalized administrative contested case procedure. It's sort of like court, but it happens in the context of an administrative adjudication, right? And so that is the standard that I'm proposing here in number too, that if we're going to actually amend or terminate a registration, that's a big deal. That's beyond ministerial, and that should be protected and governed by a contested case procedure. The first part of it, rejecting a record that contains false, fraudulent, or clearly erroneous information, isn't quite as formal, and that's for clear violations like, you put that your business is located in Boston, Vermont. There is no Boston, Vermont. So we're just gonna, even though you're submitting that and technically our duty is ministerial, I think it makes zero sense for us to file a record that says your business is in Boston, Vermont. That's clearly either a mistake or that's fraud. We're not sure which, but we don't need that in the public record, right? So that is sort of the conceptual framework underlying the proposal. And then I want to look in depth now at that section as I've written it and see if you have questions. So I'm going to take us back to 11 VSA chapter 15. Remember, and again, the proposal is to first expand the title of the chapter so that reflects the components of it. 1, organization-specific filings. 2, administrative authority. 3, administrative revision. So we'll create this new subchapter. We've already looked at this stuff that relates to this, the specific registrations. And we'll harmonize and tailor those provisions under subchapter 1 for those registration types. And we have a bunch of extraneous stuff that's being deleted because it's addressed elsewhere. So 2 is the administrative authority piece. 1636, I've now alluded to a couple of times, is the name provision. The only change here is just because we're striking 1621C and it won't live on in the same format. We're just going to take the distinguishable and the record standard and have that proper cross-reference. 1637 is another existing provision that talks about the ability to terminate and amend a registration, but honestly, I don't know if this has ever been used, and I don't know if it would ever really come up. It is basically limited to a business that somebody else, a court, maybe an administrative authority, has decided for some reason is not allowed to do business. So this might manifest under the Consumer Protection Act if the Attorney General, as part of an AOD, says you've committed consumer fraud and you're not allowed to do business here anymore. I mean, that's the kind of thing we're talking about. But this is existing law, and the only change is to say this might happen by a court order. It could also happen administrative order. So for instance, the Agency of Natural Resources decides that a polluter has done so much damage that they're not allowed to do business anymore. That would be governed by an administrative order, not necessarily by a court order. It could be a court order, but I just wanted to cover the base of some administrative proceeding. So again, existing law, not really making a change there. This, though, is the new piece: authority to reject, amend, or terminate. Can everybody see the words okay? Is it big enough? So under A, the authority is 1, to reject a record submitted for filing the secretary reasonably determines contains false, fraudulent, or clearly erroneous information, and 2, amend a record or terminate the registration of a person who the secretary determines, after notice and opportunity for hearing under the Administrative Procedures Act, has submitted false or fraudulent information in a record, or has attempted or submitted a record for filing in bad faith without lawful authority, or to commit fraud or cause injury. Let me finish this section, then we can talk about those in detail. So B, if the secretary terminates the registration of a person pursuant to this section, or the secretary's rejection or amendment of a record results in a person's failure to designate and maintain an agent, the secretary is the agent for service of process. Talked about that, and it's under the standard provision we just discussed, 1656. And C, a person aggrieved by a final decision of the secretary under this section may appeal to the court. And it's a de novo appeal, which means they don't care what we said. They're going to look at all the evidence fresh and anew. So that's your appeal, right? That's your protection. If we did something that you think was wrong, you can now jump into the court system. So let's talk about 1 and 2. 1, reject a record submitted for filing that the secretary reasonably determines contains false, fraudulent, or clearly erroneous information. Again, this is subjective. It is a reasonable determination. It would be made by our division, by the secretary, and it would be false, fraudulent, or clearly erroneous. So those are your 3 cases. And you might ask, what's the difference between false and fraudulent? And it's a fine distinction. False is you just put something that was wrong. Fraud is more like with the intent to cause harm, right? So if somebody, we get this one a fair number of times. We get a person who used to live somewhere. They have a business. They used to use that as their address. Now they've left. So the business should be at a new address. And then we get the call from the landlord or the mom or who knows, the new owner that says, this person doesn't live here anymore. They've lived here in 5 years, but I keep getting their mail. All right. If the person came back to us and filed an AR that had that address again, we'd probably want to reject it and say, we've been notified that you don't live here anymore. Could you clear this up before we process this? And if they say, oh yeah, sorry, I'll amend my filing, great. We'll just dispose of it. So that's when they come back to us and we think, oh, this is false because you don't live in or something like that. It's a clear error. Boston, Vermont.
I mean, I feel like I've seen in filings people making smaller errors of just misspelling the name of their town
Sure.
and things that are not necessarily clearly erroneous, but that's not really the zip code for that place.
Right.
Are you going to be going through at that level of rejecting if someone just spelled Westminster with 2 M's?
I mean, it's in their interest for us to reject that because then they don't have to pay for it and it's not wrong in the record. So most of the time, like 99% of the time, these get resolved amicably. Like we say, like, oh, we see that you misspelled this or something like that.
You fix it for them.
Right, and we don't have the capacity to fix
Yeah,
everything
that's right.
for them. Yeah, but like if we filed it and it's wrong, and then they go to the bank and the bank says that we see this as a mistake, then they have to come back and pay us for an amendment. So now we've doubled their work, which is not what we want. So 1 is really the light touch thing where we see, maybe this isn't right, or we know that it's wrong and we're going to reject it and reject your payment so you don't get charged the fee and then you can fix it. And we've got a legal leg to stand on. We can point to this and say there was whatever error and you can just refile it, right? That happens plenty of times now in all kinds of instances. It's really 2, the bigger issue and the one that's important. And this is where, we get a complaint and somebody says, this LLC is still in the public record using our address or saying that we're the owner, or they're trying to, we've been getting, credit cards or loan applications or who knows what. And they say, I want you to take that down. I don't want that to be in the record anymore. That's not really a thing right now. We don't really have the legal authority to just expunge an LLC that exists in the public record, even if it's clearly false or fraudulent, even if we know that some fly-by-night person has taken your name and your address or your whatever and is trying to apply for credit cards online or trying to mislead the public for some reason. I mean, and that leaves us in a really tough spot And that's happening, increasingly across the country. And I've talked about this before, whether it's co-opting an identity or it's building a synthetic identity where you're using elements of actual people's information and then making other stuff up, or it's the person in Burlington who can't get the address off of the record and is still getting solicitations in mail and very distressed. I've lived here for 35 years. This person is not associated with this address. Do something. And I'm hard pressed to be able to point to a section of law and say, okay, well, I'll take that off. So that's the thrust here, but it's not light. I'm not going to just undo it. If that happens, if this becomes law, then I'm going to issue a notice to the person submitting the complaint and to the person who's on record. And we're going to have a hearing. It's going to be adversarial, and there's going to be a finding of fact, and there's going to be a decision and an order. And that's going to go into the record as well, associated with that business file. And it's going to show that this proceeding occurred and this was the result. That way, there's always a paper trail of evidence of official legal action. I'm sorry to cut your question off.
So I have two things now. One of them is, how does this really compare to what other Secretary of States or other states that have business, wherever they have their business office license or registration, there's the word. How does this compare to that in other states?
So
Because it seems perfectly reasonable and
Sure.
like, why don't we have that?
it's a great question. The reason is the tension of the ministerial duty versus public protection. And again, and
But I guess, do we know how it works in other states?
yes, well, yeah. So the answer is it really doesn't work in most other states because of that tension. So Colorado, Rhode Island, a few other states have either adopted or are considering comparable provisions. But I got to tell you, last summer, I heard a presentation on Colorado's process, and it took like 6 weeks for them to resolve. And most of these happen in like days. Like somebody comes in, files, submits all these applications for credit or loans or other licenses or anything else, and then disappears. Most of the time, it's criminals. And by the time you've had a 6-week adversarial process, who knows what harm has been caused? So this is less than that. It doesn't have like step 1, phase 2, phase 3. This does follow the APA. It does require notice and determination and then issue an order and all the jazz. But it doesn't build in a 6-week time frame. It doesn't build in multiple appeals. It allows us to do this expeditiously. Like if I get a complaint on Wednesday, I can send out the notice that afternoon and say, in 1 week, we're going to hold a hearing in Montpelier. So by then or before then, you need to present evidence that the claim that this is not your address is or is not substantiated. If I receive evidence that it's contested, then we're not going to get in the middle of that. And I'll give you an example. There's a divorce happening right now. There's an LLC involved. Former estranged husband and wife keep coming to us, filing things against it to change who's the owner, where mail should be sent. Like, if I get that initial complaint, I reach out to the other party and say, we have this allegation. Do you want to respond? But if the second party says, no, we have the right to do this too, then that's it for me. I'm not trying to get in the middle of those kinds of things. Those are court appropriate proceedings. I'm trying to have an expeditious resolution where probably fraud and probably will be resolved pretty quickly. Most of the time because the person doesn't respond. But so like in Colorado, even if they don't respond, it takes multiple steps and layers to get to resolution.
So it seems like we need to do this to keep up with the times and how things are working today, right? We're not mailing things.
It's a great point. It is so easy to file an electronic record. And one thing that I think the world doesn't appreciate is that it's a system built on the laws that we have that says trust, verify, and if something goes bad, we go to enforcement. It's not trust, verify, limit on the front end. Only you can modify your business record. That's just not how the laws are written. It's written so that if you modify a record you're not supposed to modify, you've committed perjury, and then we have enforcement by law enforcement. But that is not responsive to the speed at which electronic filings occur. So this is, trying to get the cases at the most extreme end of the margin.
As I'm looking at this, it feels like it would seem to me that in future years, you would come back to us and say, we also need to collect this information to retain for these fraudulent cases. So I'm just gonna look for that in the future because we need to start with this and then we'll understand what happens.
Sure. And it could be, like I said, I started this job. We had like 5 of those contested case name proceedings like in the first few months, and there hasn't been one since. We had a really tough stretch of a few months where multiple address issues came up and then nothing. So, how frequently, I can't say, but it's not a lot, and it's certainly not as much in Vermont as it is in other states. Massachusetts is just being overrun with these fraudulent filings, but it is happening.
Do you foresee a need to increase personnel to moving from ministerial alone to this new sort of arrangement that
Sure.
that 2 and 1, I guess, positive? Is there likely to be more time that this will cost your office and personnel?
I don't think so. I mean, I guess there could be an explosion, for whatever reason in cases. I think we can handle it. And I just say that based on our experience in the past, 16 months. I mean, it's something I personally do. I mean, I sit in Neil's there and we sit down at the table and we have the people come in and then we write the decision and it's done. So it's, it is work, but I unless there's like a significant uptick in the number of incidents, I don't see it being a problem for capacity. How are you generally feeling about that? Everybody feeling okay? You understand the need and the response?
1 and 2 so far, right?
Yeah.
Nervous
Okay.
that as you enter a new, that's what I'm trying to understand is, are you entering a new forum? Or are you simply entering a forum that you're in all the time? Like with that LLC situation you described,
Sure.
armed with the statute that enables you to actually do something about it as opposed to whatever. Because I'm just curious, what are you doing now with the LLC situation with that divorce? If you don't have this.
Well, so for in that case, that was an example of a place where I'm not going to get involved. I mean, because that
you guys need to work that out for yourself.
Right.
That's not a thing that Secretary of State. Well, and that's what I'm wondering. Are you now going to be a party to this in some way? Because people are going to say, no, it is fraudulent. And then you for the side of it.
It's a fair question. And my answer is I don't think this is going to change the landscape. I think the landscape that we're in is the one that we're in, and that is the periodic, complaint about the address or the name of the something being used without authority. And this just gives me a clearer legal leg to stand on when I do something about it. Do you know what I mean? Because right now, we're sort of interpreting 1636 liberally to say there's a challenge to whether or not this person is doing business under the name. That section is really supposed to just be about conflicts about who gets to use the registered name or whether the registered name is being used in a business. And I want that to be limited to name issues. And I want this to be the legal leg I have to stand on when somebody wants to challenge the veracity of information in the filing. So I don't think it would in any way increase those occurrences. It would just be a better tailored approach to address those occurrences. Okay. So 1639 is the actual language that we started this conversation with on the yellow, the ability to adopt forms, procedures, and rules.
I did it in 1630.
Oh, please, go ahead, go ahead.
The language in B
Mhm.
appears to be a little different from the language in B as we have in the legislation from Rick,
Mhm.
where there's like a B1
Sure.
and 2, and I'm just wondering if that has to.
That would govern.
Okay.
Not all of the updates in that made it, but substantively it doesn't.
Because B1
Yeah.
does not specify section 1656 of this title.
Okay.
And I wasn't sure if you needed that language.
Yeah, that's just a helpful signal to the person. I mean, I can work with Rick, could put it back in there, but 1656 would apply and govern regardless of whether we reference it. It's just, I reference it in all those other places just as a helpful signal to the reader to know,
Okay.
you're subject to this other provision.
Great. So I just wanted to mention that.
Yeah, no, that's a great catch. That's great. That's what I have for yellow, unless you have more questions about the administrative piece. Any questions?
About the yellow, but about everything here
Mhm.
overall for me. Does any of this create a new need, a new response from existing businesses that they have to do something different, provide you more information, pay a revised, updated fee, any of that kind of stuff?
Well, the fee provisions specifically do change fees. It will depend very specifically on which document you're filing, and I mean, we can dig into those, but so yes, on that, in that sense, but as far as like the substantive provisions, I mean, does it require a business to do something new or different? No. I mean,
Perhaps upon renewal of some
y-
type of thing or other.
so for instance, in renewal, it doesn't change the duty. There's like for your report, let's say for an LLC,
Mhm.
it doesn't change the duty. You still have an annual report that's due. What this would do is say very clearly in statute, when you submit your annual report, you can change these information points. So it's not a requirement. It's an expanded flexibility for the business to be able to update their information at that time. Because it's just not clear right now that that's part of the process. For the agent piece, it's not there are two instances in the agent piece where we specify the requirement to have an agent where it doesn't exist right now. One is the nonprofit cooperative association provision, where we say that if you're a foreign nonprofit cooperative association, if you don't have a Vermont address, you need to specify an agent. I don't remember the last time one of those was formed. It's probably just a handful, but that would be that agent requirement, which otherwise sort of universally applies, doesn't currently apply to that type of entity. So that would be new for them. And this also makes expressly clear that if you want to change agent information, you have to file a statement of change. So you can't do that in your AR or in an amendment. You have to use this particular mechanism. So that's different. It's not more onerous, I wouldn't say, but it sort of segregates that function to that one flow. Because, as I said earlier, we want to review those. And we don't want to risk missing an erroneous designation or a false address or something like that. We don't want you to put Secretary of State Sarah Copeland Hanses as your agent. So we're going to review all of those. For the initial filings, again, the changes there are, specifying that we want your business address, not your home address.
And that would be an initial filing as
Yeah.
opposed to something that would affect an ongoing.
Right, yep.
business.
Yep. And we're saying, well, we touched on the ARBR changes, we touched on the fees. Reserve name, no new duty. It just streamlines, makes sure everybody's subject to the same process. Simplifies that. Same with assumed name. Clarifies that 21 applies to individual assumed names, 23, what will be 53 is for organizations. No change to the registered name. Actually, I think clears things up and would take away a filing for the corporations right now. So they don't have to file a separate trade name registration. You can just do the registered alternate name. Doesn't change anything for service of process substantively. They still have to come to us with duplicate copies. We still have to certify mail it. No new duties under the yellow. What this does in this middle piece is improves life for assumed name, partnership, and UNAs to be able to keep their records up to date by filing an amendment, which is good for the public too, because that ensures that we have current information on file, not 5-year-old or 4-year-old information on file. And that's it. I mean, that's so. Other than those, a couple of examples the other piece about the agent right now under Title 11B for nonprofits, for some reason, the legislature did not include the section of law that says a nonprofit needs to designate an agent for service of process, but it included all the other provisions that talk about, when you change your agent, when you file your biennial report, tell us your agent. So it's a really curious thing. I don't know if it's one of two things. It was an oversight by not including it, or it was an oversight by including everything else that still makes you have to have an agent, but not actually imposing that initial duty with your formation. So we've erred on the side of going with however many decades of practice where nonprofits do have agents for service of process. That's certainly, a policy choice for you guys. If you want to make nonprofits not have agents, I guess that's up to you, but it doesn't really make a lot of sense. So that is, it's new statutory language. I wouldn't call it a new requirement, but do you follow what I'm saying? Okay.
I think we would have to take an awful lot of testimony to change the practice of requiring an agent, wouldn't we? Like, is there a reason not to require an agent for a nonprofit if it's a business, just like all of these other businesses that are required?
Right. That would be a big shift to suddenly say, you guys don't have to have agents for service of process. That would certainly be inconsistent with the way things work right now. It's just that one section of law is missing. But like I said, when you file your BR, you have to tell us your agent information. So clearly there was an intent to have an agent. I just think maybe that was an oversight. But it's funny how it's been a glaring omission for 30 something years. I never noticed it, and all the time I was working with 11B, so that's funny. We did have an effort to rewrite 11B, 8 years ago maybe, and it just didn't work out. So that may be right for a change, I'm not sure, but Um, so that's, oh, the study, we didn't look at that. I know, gosh, you guys are excited about that. So you, I mean, would it be accurate to say that this is a placeholder? Maybe. I mean, I wrote this in very generic, broad strokes to raise the issues that I think you might want to consider down the road. So first, threshold matter. You don't have to have this. These are things that we're going to continue to think about and decisions that I don't feel comfortable recommending changes until we get input from the people whom it would affect and from you, and then ultimately you would have to make the changes in law. But these are some of the sort of the big picture items that we should resolve at some point in Vermont's future.
Do you think that you need legislative appointments on study?
So, two ways to answer that. No, it doesn't need to be legislative appointments. I understand the cost and time, exigencies. I get it. But to be frank, when a legislator, one House, one senator, or two from each participate, there's going to be a lot of complicated nuance involved in each of these issues. And it's going to be hard to, without a champion in the legislature, that members of the body can come to and say, like, what in the world's going on here? I mean, that's a role that I can certainly play. People who participate can play, but like, if we come back to this committee, for instance, with this massive proposal that makes some pretty substantive changes to different areas of law, it would be really good for somebody who's excited about this stuff to have had the experience and the benefit of hearing those conversations, understanding the perspective of all the people involved, and be able to articulate why this matters, because this is pretty dry stuff. And usually people from this committee and your Senate counterpart sort of love to dig in on that sort of nuance and that detail, and can be great champions for it. That said, that we have to go through the exercise anyway, whether a member is on the committee or not. And we have to bring everybody up to speed, and we have to explain that nuance and that background to everybody. So, would it be fatal if we didn't have legislative members? No. And for that matter, do we have to have the formality of a legislative study? No. I mean, this is stuff I want to look at. This is stuff I'm going to ask people about. I've already raised some of these issues, for instance, to the Vermont Bar, to the banks, credit unions, labor. This affects people in the community. So, again, I don't feel comfortable coming to you and saying from my seat, we should make these seismic shifts to partnership law. That's not appropriate for me to do, but I could do that. I could facilitate that conversation with people. So do you want to, I can give you a rundown of what's just the highest level of what each of these things are, and you can noodle it or, whatever you want to do. So one, technical, procedural, and substantive issues concerning the online business filing system. I mean, trust me, we get that feedback all day, every day. I put this here in more of a sense of like a structural conversation about, we've got it now built, it's new and exciting, everybody's using it. What more do you want from it? Do you want us to collect voluntary demographic information from filers? Do you want us to enable this type of functionality or that? Are there really significant things that don't work, even though they work, that you would like to see change? And to have a sort of a more formal public forum for that conversation to solicit feedback. Two, statutory revisions to adopt provisions of UBOC or other to further harmonize laws governing business organization in the state, including provisions governing commercial registered agents, involuntary termination, reinstatement, continued right to use a name, period for revival. So we talked about, and you had asked about what's the gold standard and what other people think about it, and UBOC is that standard. And I mean, I can probably tell you most people don't have the appetite for it, but it's maybe worth having the conversation of to what extent do we need to try to further harmonize things? Because this bill goes steps in that direction, but it doesn't make things identical. Like every different initial filing is called something different, you know? Articles of organization for an LLC versus articles of incorporation for a corporation. They're all just a little bit different still. And I suppose you could go radical and say, we should only have initial filings, amendments, annual filings, closure filings, statements of change, if even that. I mean, you could really, really distill things down to their essence and have, 6 documents that govern everything and they're all called the same, they all work the same. That is certainly not how the law is working right now, but is it worth having that conversation? Maybe. For 3, statutory revisions to the laws governing trademarks and possible expansion to include service marks. I'd initially intended to include that in this proposal, but a new service mark and trademark set of model language came out, and I talked to some folks at the Vermont Bar about whether we should just proceed or whether we should take a look holistically at the trademark and service mark legislation because it's pretty old. And are there any updates? But I would not make those kinds of recommendations without subject matter experts who are affected in that field. For revisions to the dual framework governing partnerships and the mandatory registration of assumed names and UNAs. Touched on this already. The way the wind was blowing was towards Corporate Transparency Act, towards everybody, individuals, sole proprietors, partnerships registering with a federal government, right? And we've had a seismic reversal in that trend in the past 2 months, 3 months. And, I just think even if we just decide to maintain the status quo, probably an appropriate time to reflect on that requirement of registration and decide, like, if you think it's of a public benefit for assumed names, partnerships, UNAs to register because of the information function and the protection function, then maybe a 5-year registration doesn't make any sense. Maybe it should be annual. Or maybe we shouldn't be registering these people at all. So, or it could be optional, not a mandatory. So that's something to think about. 5, assessment of the need for any updates to current model laws or the addition of new model legislation. So even if you didn't go with UBOC, there have been updates to the other model acts. There's a new revision to the LLC Act from a few years ago. Like I said, we tried to do a comprehensive rewrite of Title 11B for nonprofits. That did not happen. What's the appetite for that? I'm not suggesting necessarily that this bill or even the next bill be the place to adopt those, but rather, do you as members see a need for any of those updates and want to introduce legislation to update the LLC laws like you're doing with UCC right now? And then the last one, assessment of the administrative oversight authority and substantive provisions governing data brokers, telemarketers, utility co-ops, and amusement ride operators. So these are the sort of random assignments that we've aggregated over the decades. And, I think you're obviously taking a good look at data brokers right now, but I'm just going to say it's a wonky thing we have where they sign up, they file with us after the activity has already occurred. And it's not licensure or registration. It's just a notice filing, but it doesn't happen until January of the year that you already did the activity. So that's weird and worth thinking about. Telemarketers, sort of the same thing. I don't even know, are there still telemarketers? I'm not even sure. Sure there are. I don't know. mercifully, I don't get bothered by them all that much. Maybe it's because I don't answer my phone. Utility co-ops, I realize we haven't really talked about, but it's this, super esoteric provision in Title 30, Chapter 81 that I don't know if anybody's made a new utility co-op in how many decades, but it's technically charged to us to register them. Should that be with us? Should that be more just a PUC function? I don't care that much, but it's just worth talking about. And then the last one is amusement ride operators. And this one I actually think probably should be explored in some detail and probably committed to public safety. And I don't mean to just volunteer a sister agency to do work, but I'm not sure how much sense it really makes for that workflow to come through our office when the substantive risks, approvals, processes are all really about public safety. And maybe you want, them to be the people who do that. But
So looking at the amount of work and the on or before date and realizing that if we want to do something next session, it would have to be much for that because of the deadlines for language for bills. And so I might push it to November 15th of 26 for the next session and I think a report might be the right way to go just because that's an awful long time for some kind of a working group, but I think there's a lot there, right? So that's my first thoughts on this. Like, let's be practical about the timeline and about the amount of work and what we really want, what are the priorities?
Sure.
Right.
I think it's a great observation. When you say it out loud like that, I arrive on the other side of it, which is I'm not even sure January 15th is enough time to do this much work. Because, if you got 6 major themes here, let's just say you take even 2 meetings for each, which probably isn't enough, then you're cramming that in on a 4 to 5, 6 month time period plus a work product. Probably not feasible. So I stand guilty of dumping all this on your lap and saying, let's figure this out in no time flat. So yeah, again, that's why I sort of started this with maybe this is a placeholder and we want to have more conversation about what this should actually be, or if we should do part of it now, part of it later, or you're the deciders.
I think that, thought would be to just ask you to report back to us and you decide who you want to talk to but what are the things that you can get done? So we have something back in November that we can act on and then, but continue on. So there's a final report maybe in December of 2026 for the next, when the session starts. So there are things in there that we can do now that there's time to do and then continue on. So you have like a 2-year process. Makes sense?
It does. It does. And if you do it that way, rather than trying to have the formal structure of some special committee or whatever, that probably gives me more flexibility to have, whatever conversations I need to talk about the appetite for pursuing this or that, and then what the process should look like. And then I can come back to you and say, this was immediately a non-starter. This is one where there may be some room for improvement. This is one where people say, yeah, we want to do this, but we really need to dig in. So it may be better to, sort of sort it by, I don't know, priority, right? And feasibility, and then come back and say, this is the landscape. These are the things we think you should pursue. These are things you can ignore. These may be worth further exploration. Okay.
I think we just list everything that's there. Say, go out, come back to us. with an initial report in November and then whatever language, whatever recommendations you may have.
Sure. Okay, I can do that.
And we can say a final report in December 2026. Okay. Okay. All right. But we'll do that.
Okay, well, I am sad to say that that more or less brings us to the end of the conversation, which I know you're really upset about. It's been very fun. But I'm happy to talk about any of this with you ad nauseum in depth because I enjoy it very much. So if you want to follow up, please feel free to reach out to me.
Certainly will. Maybe we have probably 10 minutes or so. Just kind of start with Rick, and I think the walkthrough can be fairly quick. Because we've had a pretty in-depth overview of what the bill does, so maybe just look at the language. David, thank you.
Sure. Thank you.
Yeah.
You're gonna leave right now, Monique?
Yeah, I appreciate you so much.
Actions speak louder than words.
Rick.
Yeah, okay,
Complete trust.
could be. Rick Sagel, Office of Legislative Counsel. I will join the Zoom here momentarily. This is your second 100-plus page bill in 2 days. So congratulations. And I was, again, I am just the conduit for these two bills. You had Carl Wisman yesterday and David Hall, former Ledge Counsel. I'm sure he said that 1 or 2 times, helping with this one. So I do want to start off. I listened to David's testimony, not just today, but in the previous couple of weeks when he testified. I know you had a question about some more where the fees weren't cross-referenced. Did the committee want to update any of those specific concerns, or were you satisfied with the bill when it comes to those cross-references? Were you satisfied with the way the current language is?
We're gonna leave key things up these means upstairs and let them, they can figure out how they want to do that.
Okay, great. Let me share the document then. Okay, I was working on the report language, but let me go back to the top. Do want to point out just one thing just to consider. And when David sent me this proposal to rename a title, I'm like, can we even do that, right? And turns out we can. It's not very often. So, grabbing one of these books here, every title has a name. It's got a title, right? And Title 11 is currently named Corporations, Partnerships, and Associations. I don't know how long it's been titled that, probably for quite a long time. But the recommendation or the suggestion proposal here is to rename Title 11 from Corporations, Partnerships, and Associations to Business Organizations. It's it may not seem important. It's pretty important because it's on all these books. So there's a small cost there because we'll have to obviously, David's given me work to do over the summer. Well, thank you. It's funny he waited until I replaced him to have this brilliant suggestion. So it is, I joke, but it is significant. We haven't done this in several years where we actually rename a title, but it is up to you all. And I think it's fine based on, it does kind of reflect the change. We don't want to do it just casually. I think it's reflective of the changes that is being proposed here. So I don't recall if you all discussed that or not, but for me, I want you all to be aware of what that means. Otherwise, I think, David walked through a lot of the harmonization, the fees, makes it, I think, easier in a lot of ways, instead of having to change the fees every year, every 2 years, to just cross-reference a specific statute referring to those fees, I think makes sense. The new proposed language, mostly about fraudulent filings, I don't see any issue with that. I think it also makes sense. And I put a lot of trust in the Secretary of State's office. They know what the issues are. They know what they need to filter out what they believe are fraudulent filings. So with that said, I know my time is limited. I could read you word for word this bill. But like the UCC bill, I do put a lot of trust in the provider of the language. And I did work with David quite a bit on making sure it's, fits in with the current title. And we had a few questions back and forth. And you'll see some yellow highlights. This is 1.2. I'm not sure you have that pulled up or not. The yellow highlights are really more technical between me and him that we caught recently. It's not new necessarily language, is just things that maybe I missed the first time or he missed. So I'd be glad to answer questions of what you think, if there are specific issues with this bill, or if you think that something's not clear, I'd be glad to clear that up for you.
I think the only thing we need to do is the study that's in there is to we got to reflect our discussion with David.
Yeah, and let me make sure. So we're on section 28 at the very end. Get rid of this. So I've already made a change here, just as you all were talking. I removed the honor before, and just so subsection A is now the Secretary of State shall conduct this engagement process. And if you want to change anything there, let me know. And then I added a subsection B, saying that they shall follow an interim report based on the work set forth in subsection A of the section. I might have tweaked that a little bit. I just typed it a minute ago. On or before November 15th, 2025, and a full report on or before December 1st, 2026, with this committee and the Senate Committee on Economic Development.
Maybe just instead of full report, a final report.
And again, you can be more prescriptive here. You can describe what you want in the report. Do you want proposed legislation? Do you not? Or do you just want to leave it up to them to?
I think we leave it up to them to propose any legislation that they think we should be looking at or something to that. But yeah, I think it's.
I was gonna say, did you leave the first paragraph in before number 1? Shall conduct public meetings with interested partners to consider and if appropriate, submit proposed legislation.
Oh,
See, this is why, shouldn't draft on the fly. Consider and address the following issues. Okay, and then down here, do you want me to put back proposed legislation, or again, leave it up to the?
I think it's fine in either spot,
yeah, it's already up there.
as long
So,
as he pulled it from the top though.
oh, okay.
Make sure it's in one of the places.
I pulled it from the top, yeah. Because it doesn't make sense to have that in A. You want to put that in B if you want the proposed legislation.
Yeah.
Not the right words, but flag necessary changes and propose, right, include proposed. I think we need to understand where changes need to be made in addition to, like, I don't know. I think if we only have including proposed legislation, is that missing something? That's maybe my question.
But the proposed legislation is linked to the final report.
Yes, I made it
But what if they come back with an interim report where they looked at like 1, 2, 3, and here's what we could do now?
Yeah.
So maybe we talk about any proposals in both the interim report and the final report.
So you want both of them to potentially have,
Right. And if you want to noodle on that a little bit, that's fine.
yeah, that might be helpful. We have 7 minutes,
But, you have this afternoon after.
a lot. I have Senate floor and then I guess I have this committee, so. And possibly something else.
Yeah, that's right, because you're doing.
42.
Right?
Yeah.
So we're already gonna take care of the Vita bill. Committee, do you feel good about this bill, making this change? Are you okay? Do you need any other questions? Do you want to go through line by line? Are you comfortable with David's explanation and his references to the line? Tell me.
I think where we are, I wouldn't need to touch.
Okay, so.
I'm good.
So why don't we let you do that, and then when you come back, we'll do the Vita bill, then we'll try to move this one, then we'll go on to 342. Does that make sense?
Makes sense.
Okay. Excellent. So we'll do. So we're on the floor at 1 o'clock. And then 10 minutes after the floor back in here. And we'll go. Yeah, we'll
As
go.
late as, say as late as.
Yeah. So if you do the vote,
We'll do the two
Later.
bills
No, we'll
first.
just, 2 bills will get done first. Then we'll
oh,
go into 342. I'm anticipating 5:30, maybe 6 o'clock.
okay.